Welcome to our post-storm consideration class, where you're going to hear some details about what your clients can do, or what they need to do, or what they should be aware of before, during, and after a storm. So we have a great panel here with us today, and we're being moderated by Deborah Patel-Hogg, who is going to let you know a little bit about our panelists and get us started on our sessions. Thank you for being here.
Hello, thank you. It's my 42nd year in real estate here, so I'm kind of what you call an old timer, but I hope not to look like one. Okay. Our panel are all members of the Realtor Attorney Joint Committee, and I'm one of the token realtors on the committee. And so I'd first like to introduce Amy Concilio and Garret Barnes and Michael Hankin. Okay. And we're going to try and get through these questions. If you have a question, just raise your hand, and then they will repeat the question and then answer it, because none of you are mic'd. So, okay, Amy. Can you sell a home after casualty damage? And if so, what are the most important disclosures?
Hi, everybody. Amy Concilio. I'm an attorney with Williams Parker. And to answer the question just with a one-word answer, can you sell a home after it's been damaged? The answer is yes, of course you can. The most important thing that you can do is disclose any damage that occurred to the property. So disclosure does not mean current damage. Disclosure means damage and repairs. Disclosure means damage, and I put a couch in front of it so nobody would see it. Damage means any result of a storm. So you can certainly sell your client's home after a storm, provided that your client discloses all of the effects of the storm. On the other side, can you buy a home? Can your clients buy a home after a hurricane or any other type of casualty damage? And again, the short answer is yes, of course you can. However, your client has a responsibility as a buyer to do their due diligence. And we'll talk through today kind of some horror stories that may scare you into some additional inspections or some additional due diligence items. But the answer is always yes. You can buy and sell a home that, maybe lost one roof panel or lost the whole roof. But, as realtors, you have to advise your clients to make sure that all items have been properly disclosed. Because as you know, if these items come out after closing, you've now set your clients up for a lawsuit. Anything to add, gentlemen?
Okay. I forgot to introduce Amy. I'm sorry.
I have a little bit to add.
Okay, good.
As a realtor, if you have a home that's listed that gets damaged, you're in a little bit of no man's land. The listing agreement has no force majeure clause. It has no provision for what happens if there's damage. So unless your broker has specific provisions in your listing agreement that tells you and your seller what to do, you're in a little bit of no man's land. And most likely the advertisements that you have for that property are now misleading if the home's been damaged, because they're showing a perfectly constructed home, which now has storm damage. And if somebody puts an offer in based on your advertising, you could have an issue with failing to disclose the proper condition of the house, as Amy was mentioning. Also potentially an ethical violation for not being true with your advertising.
Great.
One other thing I wanted to mention with that, and the second part of that question was, what are the most important disclosures? Not too long ago, Florida statute put out a mandatory flood disclosure. It's in the Florida statute. It's 2 questions, I think, or 2 questions with a couple different parts, that basically asks you if the home was damaged by flood and if there was a pending insurance claim. I still get contracts routinely where I don't see this disclosure. I am hopeful that the disclosure was made and the realtors have shared this disclosure with the buyer, and I just don't see it, but I'm afraid people are still not using it. So just keep that in mind if you are listing a property. the seller has to disclose this statutory language for flood damage and for any pending insurance claims. Sure. So the question was, in the flood disclosure form from the statute, it only has like check boxes. So essentially they're yes or no questions. So then the second part of our question was, do you have to disclose the details? And the answer to that is yes. On the seller disclosure form, there are lines for flood damage details that you can add there, but there really is nowhere to write in your insurance claim details. So what I would suggest is either crafting an addendum that gives as much detail about those insurance claims as possible, or just creating some type of paper trail so that the buyer is advised of any claim that was placed on the property. So again, you can do that via email if you'd like as a paper trail, but I think best practice is probably an addendum that just lays out all of the details of any claim on the property and have the buyer initial.
Yep.
So the question is whether it's preferred to do a new seller disclosure or update the one, I guess, that's already with the listing. So if you have a property listed, it experiences damage. I don't think there's a right or wrong answer to that. I think if it's a one minor item that you can just amend and do an amended disclosure, that's fine. After a hurricane, if you lost the roof, you lost the drywall, you lost the floor, I would say just do a whole new disclosure form. So the question was, if a pool screen, I guess, gets destroyed or blown away, can you just amend your first disclosure? I think it would be fine to amend it for that. No, the question was, I had mentioned I'm not receiving the forms, and the reason is because they are not part of the contract. You're right. They are not an attachment to the contract unless specifically referenced in the contract. So that's why I say I hope that those forms are still being sent out. I'm just not always seeing them, and they are mandatory. Yeah, I think there's a lot of things about the statute that don't really work in practice, right? There's nothing even in the statute that says what happens if you don't send it. I'm of the impression and of the opinion that if you don't disclose something like that, you're opening your seller up to a lawsuit. But the statute is not specific on that. One way you could get around it is you could incorporate it into your contract by adding language into Section 20 that says the flood disclosure is attached and incorporated herein. And then once the buyer signs, that incorporates it into the contract.
Okay.
Just one addition to that. As realtors, and actually any real estate sales associate, you have an obligation as a transaction broker, independent of the seller, to also make disclosures about the condition of the property that you're aware of. So if your seller doesn't, and even if you say, hey, seller, you got to do this, and they say, I don't want to, you still have to as your own independent obligation, separate and apart from the seller's obligation.
Okay, then. Next, I'd like to introduce Garret Barnes, who is a founding partner of Barnes Walker, and he was admitted to the Florida bar in 1991, so he's been around quite a long time, too. That's it. That's it. Okay. Okay, Garret. How much damage did the 2024 hurricane because?
Around $500 billion. It's unprecedented. It was unprecedented in this area. You know, we hadn't had one in 80 years, and all of a sudden we had two back to back. So they're anticipating or estimating around $500 billion, and it's impact every one of us and people that we know. I think that's for the storm total in Florida. Yeah.
Okay, I want to ask you one other question. Is it difficult to find qualified and licensed companies to perform the property repairs and work?
Yeah, I think we all know the answer to that is yes, because it all hit at one time and everybody's trying to get their own properties or properties they control fixed at the same time. Nobody has been very happy with the timing because, again, with trying to find the right people, there's also lack of materials. So you just have to be patient, and eventually it'll get done, and be very careful of who you have done, and making sure that the people are legit, licensed, that type of thing, and the proper permits pulled. Remember, there are a lot of permits that are required on some of these repairs, and a lot of the regulations to follow, such as I think he's going to talk about a lot of the 50% rule and some other things.
And just a quick note on contractors. If any of you are not aware of this, the DBPR, Department of Business and Professional Regulation, I think, their website, you can check to see if a contractor has a license on their website. You can check by the entity name, you can check by the individual's name, and it will tell you if they are a licensed contractor. If you cannot find their name on the DBPR website, you should not be signing any agreement with them. Yeah, I have a couple clients who have signed agreements with individuals who are promoting themselves somewhat as developers and not contractors. That's very risky. You then have somebody who you're entering a contract with one party, yet another party is probably doing the work, and your homeowner has no privity with the party that's doing the work. So the liability is a little questionable there. So I always tell my clients to check the contractor's license number. With a good contractor, they will have their license number on the first page of their contract. So if you don't see that and you feel like it's hard to figure out if they're licensed, they're probably not, and you should steer clear.
I don't know.
I don't know either. If they have a license on the DBPR, I think they're safe to use. I don't think that just I think it is just CGC. I don't know if just a GC has a different type of license, but as long as they are licensed and there is a board that you can report them to, then that gives a little bit of comfort.
Yeah, you see a lot of people going up and down the streets. Hey, I can fix your roof. Hey, I can remove these trees. I can cut these trees down for you. There's a lot of liability for those folks to come on your property. And a lot of those fly-by-night folks don't have any insurance or license, that type of thing. And the proper answer is no, thank you, and you get the right person to come in. So you have to be very careful, very careful out there.
Just one other, cautionary tale is be careful with out-of-state contractors. A lot of out-of-state contractors came in after the storms and, tried to sign people up, and they were not registered with the city or the county, so there were a lot of delays in getting permits because they were out-of-state contractors. So just keep that in mind, that just because they may be licensed in another state does not necessarily mean that, you or your client should be contracting with them for Florida property.
Okay, last but not least, I'd like to introduce attorney Michael Hankin, and he focuses on residential and commercial real estate transactions, and he has over 20 years of real estate experience. He's also earned the distinction of being a board-certified real estate attorney. And okay, question number one for you. What happens under the FAR contract if a hurricane appears when a property is already under contract?
Thank you. Paragraph 18G of the FAR contract has a force majeure clause. And what that clause provides is that if a force majeure event, such as a hurricane or other act of God, prevents the performance of one of the parties under the contract, then that obligation to perform whatever that duty is postponed. And it's postponed up to 7 days after the force majeure event no longer prevents the activity. So we primarily see it when a hurricane comes in and you can't get insurance because insurance underwriters don't write insurance when hurricanes are in this imaginary box of longitude and latitude on a map. And that is a service which is not available, insurance. And the contract extends all the time periods for up to 7 days after you can then obtain insurance or whatever other services you are prevented from obtaining. There's a provision in the contract which puts an outside time period of that of 30 days. So if you go beyond 30 days, either the buyer or the seller could terminate the contract.
Okay. Questions? No? Okay. Thank you.
So you have 7 days after you can do what you need to. So if you need to get insurance and the hurricane stopped you from getting insurance, 7 days after you get insurance, you have to close or do whatever other obligation you had. If the storm prevents your obtaining insurance or anything else that you need to do under the contract for more than 30 days, then you have the right to cancel.
That's like easiest thing to get damaged. I get that. And Ian, 9 months out, basically the contractor came out to do the job. They were not bidding it. Called 28 weeks, and I couldn't even get them. So in those situations where it's not an insurance claim holding it up, it's just you need to have a pool cage because the property is fully fenced in. Now you can't get insurance because it's a pool cage and it's a child cage, right? Any ideas on what someone could do when, all parties are willing, but it's way more than 30 days?
So the question is, if you have an event for a torn screen cage for a pool cage, which you can't remedy within the 30 days, what happens? If it is during the storm, and that happens during a storm, and you can't fix your pool cage within the 30 days, which prevents insurance from being available, I would say then you are, you could be able, you would be able to terminate. You get to the 30-day period, and that storm is still preventing the performance of you being able to obtain coverage. Pool cages, kind of as an aside, are an interesting thing. In the as-is contract, it's as is. And if you have torn screens before the contract signed, that's how they are. That's life. And your buyer's stuck with the torn screen cage. On the non-as-is contract, the repair limit contract, the seller's obligated to repair any torn screens. So if you have a property with storm damage and you think, well, it's mostly okay except for these screen cages, you may be still liable to fix those screen cages. They're something that's specifically called out in the contract and treated differently.
Maciek, I would say if both parties still want to close, if the path of least resistance is to have one of the parties, buy the child gate, then just put the gate up for as a quick fix, then maybe escrow funds for the pool cage. The holes. Yeah.
Okay. Oh, sorry.
So the question is whether we have any comments on the standard versus the as-is contract. For many different reasons, I prefer the as-is contract. I think it's cleaner. There's a lot of holes in the standard contract bats and rats, I always like to say. You can have a house infested with bats and rats in the standard contract and or the repair limit contract. And as long as all the systems are operating fine, can't do anything about it. But the as-is contract, where a buyer has a right to cancel and they find things they don't like, they have an unqualified right to cancel within the inspection period, and it, I think, better aligns with both parties' interests.
To add to that, Michael, remember, it is the seller's duty to maintain the property in the condition that existed as of the effective date through the closing. So if a storm happened after the effective date, then there is some more duties on the seller to put that property back, if they can.
Yeah, and I'm glad you brought that up, Garrett, because one recommendation that we have been making on these properties that have been destroyed and sellers are not repairing and just truly selling as is a, flooded home, you don't just want to rely on an as-is contract, right? You're essentially selling for land value. So there's language that we could propose to add to your contracts that makes it very clear that these maintenance requirements are deleted. That there's no risk of loss provision for the remainder of the contract, that it is truly an as-is deal, no warranties and no obligations on the seller from the date of contract through the closing date. If you have a property that has been severely damaged and they're selling for land value, what happens if the roof falls in midway through the contract? Nobody really wants to be responsible for that, but under the standard as is, if the seller doesn't fix it, the buyer could walk away. So you want to protect, both sides on the front end and make sure your contract essentially protects them from a situation like that.
But I also like the as-is contract over the repair limit contract as well. Just a lot more finality, less vagueness, that type of thing.
If you add the correct language to the contract, yeah, you need to say specifically that any maintenance requirements, and there's certain provisions that you're going to want to cite to in the contract. It's, section 11, might be 17, that they're all deleted. So you just need to make it very clear. But with so many homes being sold that way, we think it's best to protect everybody on the front end. Even though, you think everyone's on the same page. Everyone's always on the same page when they sign the contract, right? It's when something happens and it was, oh, no, that's not what I meant. So
I want to reiterate what she was saying. You still have to do the proper disclosures because it's still residential.
Amy, I have a question. If you list a house that was flooded and, really it needs to be torn down, do you put that language in the listing agreement or do you wait and do it in the contract?
in the listing, like the MLS listing, I'd put it out there.
Yeah.
Yeah,
Right.
it saves a headache of somebody coming in and questioning what actually is covered. Put it out there on the front end, and then you'll get the right people giving offers.
Yes. Okay.
When in doubt, disclose.
Yep.
Never go wrong with that.
Okay. Okay, Amy, can you sell or purchase a home with a pending insurance claim?
Again, like the first question, can you sell after a casualty damage?
Oh.
The answer is yes, but you don't want to. Having a pending insurance claim during a sale is messy. So the first issue you're going to have is your insurance company, they're going to look at the sales price of the home. So even if you have coverage up to X amount, if you're selling for land value only, the insurance company is going to want to use that to their advantage and lowball any claims that they give you. You also have a situation where if there's a pending claim and you close, then the insurance company is going to want to look in the home. They're going to want to do inspections. And what if the buyer is not cooperative? So we are always recommending that those claims be settled before closing. And, I know sellers might say, oh, this claim has been pending for 3 months. I'm going to get it any day. So let's just set closing 30 days out. You don't want to do that because insurance companies are notoriously slow. They're going to find some reason not to pay. There's going to be a challenge somewhere. So you can always have your closing date, X amount of days after the settlement of the seller's claim. Then you know exactly what was on the buy side. You know what was settled out, what should have been fixed. You're going to get copies of all of that, and then everything resolved. So once you buy the property, you don't have to worry about the seller anymore. You don't have to worry about their insurance anymore. You're starting fresh with your own insurance company and your own repairs and whatever obligations you may have.
I think we talked about this earlier. You know, if there's a lender involved, the lender will not close if there's a pending claim, and most insurance companies will not write until that claim is done. So, and the timing, as Amy was saying, you know, you can have an insurance claim going for a year. You just don't know what is it all be, if you're going to fight it or not fight it. Is there a lender involved that's going to review it? Do they like the claim? Do they not like the claim? Remember, because the lenders have have a lot of control over that claim as well. So you have to be very conscious about closing dates, as well as, don't close until the claim is done. That is solid.
The question is, what do you do when it's a FEMA claim as opposed to a regular homeowner's insurance claim? Because it may take longer. I'm going to advise you to wait. I know it takes a long time, but it's just not a clean transaction when there's any pending claims. And we'll probably get into it later, but I have a little horror story with a FEMA insurance claim that I'll share with everybody to just kind of be careful with those FEMA policies. The question is, what if the condo association has a pending claim? And I think it would probably be the same answer for FEMA as a homeowner's insurance claim. I don't know that I would hold up a closing for a condo association claim, but I would just make sure that it was properly disclosed on your condo rider, that everybody understands what that means. You know, if there is a huge insurance claim, to me, that means a special assessment's coming down the pipeline. Might advise everybody to review the meeting minutes a little more closely than they would have. But I think a pending claim with the association is not as troublesome for an individual homeowner. I don't know if you guys think.
Couldn't agree. Buyer has to be aware there's something coming.
So the question is regarding mechanics liens, and what I think you're asking is if the HOA has a claim out there and they haven't paid their contractor, can you still close? Is that? So that would be in, I would think in your HOA rider or your condo rider in the section regarding litigation, even if it's not true litigation, you can always disclose it there. It's going to pop up on title. So if there's a lien out there, it's going to come up anyway. So, write it in anywhere.
As a corollary issue, if a seller's made a claim on their title and on their homeowner's insurance and then not had the work done, it can create a problem for the buyer in obtaining insurance. So the insurance companies talk to each other. And so a couple of years ago, there were people knocking on everyone's door. Hey, would you like to make a claim on your roof that's not leaking? And I'll give you a $100 gift card. And they help you make a claim. You get a check from your insurance company, but you don't replace your roof because it was okay. And then your buyer's insurance company says, whoa, the seller made a claim on their insurance, but there's no new roof. There's no permit for a new roof. We now have a problem, and I don't want to insure that property because we think that the property needs a new roof. So it's important to find out if the seller's made a claim and that the work's done. Yes. No. It's great to have the involvement. So the question is, what does a seller do if there is a pending claim with FEMA or their homeowner's insurance and they still want to go to market. And I think Garrett said it the best, disclose, disclose, disclose. I'm quoting you exactly. I always say disclosure will set you free. So your obligation, the seller's obligation, is to let everybody know, properly documented in the contract. If you know you have an issue like that, disclose it, include it in the contract as sellers disclose this. This won't be, if there's something in the public records, this won't be a title objection, or this won't be a matter for which the buyer can cancel, either under the financing clause or anything else, because you know it's a known issue and you've already negotiated for it.
So I think maybe if I could talk about the National Flood Insurance
Yes.
Program policies, I
Yes.
think that maybe fits into kind of what we're talking about. So the National Flood Insurance Program is the FEMA insurance that everybody is talking about when you're in a flood zone. Those policies are assumable by buyers, and I think it's common practice for the policy to be assumed by a new buyer. It's cheaper, it's easier, it's quicker, and everybody, up until I had a call about a month ago with a client who has a disaster, up until that call, I would have said, yeah, that sounds great. Why would you get your own insurance? Sometimes double, triple the cost because FEMA policies are grandfathered in. So essentially, if you got a policy 10 years ago or you were in zone, whatever zone it was, and then it changed, now the policy would be more expensive, you're still paying an old rate. So it sounds real good on paper. But what happened to my client was that they bought their property in July of 2024. It was on the water in St. Pete Beach, and they assumed the prior owner's FEMA policy. Well, of course, all of our storms hit, and they put in their claim for coverage. And FEMA denied their claim, stating that they had paid out the prior owner, and the prior owner never did the repairs. And now the new owner is seeking to have the same items remedied. Obviously, it's flooding, right? It's going to be the same. It's going to be the same drywall. It's going to be the same floors. But because the prior owner never told FEMA or provided proof to FEMA that the repairs were made, they're now denying the claim. The new owner has no proof the repairs were made. Everything is now destroyed again. There's no home there. The prior owner never pulled permits. They were handy guys. So now the new owner is really in a tough spot. Their options are to sue the old seller, provided they can find them, provided they're, a person who you can get a judgment against, or just continue to fight with FEMA. But in the research I've done, there is no fighting with FEMA. You've assumed a policy where certain repairs have already been paid out, and now they are in their right to deny the repairs for the new owner. So it's changed my opinion somewhat on assuming these policies, and it might be better to just pay the extra money on the front end and get a new policy as opposed to assuming. Now, your question of what can the seller do if it's taking forever, I think the option is still there to close it, not get paid out, tell the buyer, sorry, we were going to make repairs with the FEMA money, now we can't, and then maybe discuss a price reduction. It's going to get messy. You probably could still go through with the sale. Maybe you escrow money. Maybe you have some type of cooperation agreement between the parties, but there's no foolproof way to handle that. There's always a risk.
Along those lines, what you're talking about is advise your client to make sure they understand their homeowner's policy and and flood insurance. I mean, they're thick, they're hard to read, they don't make any sense. But a lot of clients come, oh, well, I thought that was covered. Well, no, it's not. It says it right here. Well, I never looked at it. So when you're advising your clients to get insurance, they get insurance, but also make it with your insurance agent to go over the policy to make sure you understand it all and make sure that's the policy that you actually want.
didn't disclose it, and his agent told him, if you fixed it, you don't have to disclose. And we have a panel of attorneys at our office that told us that. When he went to sue, the attorney said, this is gonna cost me a fortune. So he ended up having to refund the whole house, $10,000.
I get the question a lot. If I fixed it, do I have to disclose? And the answer is yes. If you're asking, if you have a question as to whether you have to disclose something, the answer is yes. Always.
I think the disclosure even has the property ever leaked? So you have to answer that honestly. And again, disclosure makes you free over here.
That's correct. It's under Chapter 475. As real estate sales associates, as licensed individuals, you have the obligation, even if you're not a realtor, which I know everybody here is, you have that obligation by statute. So the question is, if a seller doesn't want to disclose something and you feel you have an obligation to disclose it, what should you do? First and foremost, have the conversation with the seller. Make them aware that you have the obligation to disclose under the Florida statutes and that you're going to follow your statutory obligation. And because you have to primarily watch out for yourself. You have your own obligations. You have to do what the law requires, or your license as a salesperson is in jeopardy. And if your seller still is insisting, I don't want to disclose this and I don't want you to disclose it, I would say, see you later. I'm not interested in the listing. I'm sorry it didn't work out. I can't do something that's against the law. I would say you're in a tough spot between
away
not
from it.
disclosing and disclosing. I would say you have to disclose. If your seller says, I'm not letting you out of the listing agreement, you said that you were going to sell my property and you don't have a provision where you can terminate your listing agreement, I would refuse and say, if I'm going to list this property and I'm going to advertise this property, then I'm going to disclose what I know.
Many times on properties that are special investment properties, where, the disclosures are empty and the seller never lived in the property, I don't know anything. What advice can you give us? Obviously, the seller has made repairs and things like that to the property owner, even if it's an investment property. So what advice do you give regarding getting disclosure for that? Is that
Well, you can't make someone disclose what they don't know. So if they truly don't know, the answer really is, I don't know. And then the onus is on the buyer to do the proper inspections. Get a good inspector, get a general contractor in there to look at some of the big ticket items and build yourself enough time within your inspection period to get all of that done.
A lot of the issues come about from people's misunderstandings. So there's a form that's floating around that says, it's a big checkbox, I'm an investor, I've never lived there, and so they don't disclose anything. But if they've owned the property for 15 years and done repairs and have encountered issues, then they do know something. And the seller and their agent may not be aware of their obligation to disclose it. So I would take that opportunity to educate them and say, you have this obligation as an agent, you have this obligation as a seller, and it's okay if you don't know anything, but you can't get out of your disclosure requirements because you just haven't lived there.
And one more cautionary tale for investors, that if there's a property manager there and the property manager knows they're an agent of the owner. I had a situation where a seller said there's never been termite damage, never been termite treatment. because they didn't live there, they were an investor. Well, the buyer moves in, goes up to the attic, and there's all these stickers on there from the termite treatment that had been done. And so we were successful in getting about $15,000 for that buyer because the seller didn't disclose, and obviously somebody knew about it. So you can't just close your eyes to things that you should have known or that an agent of yours knows. You were the listing agent? As long as your seller has disclosed everything they know, the responsibility is then on the buyer. Yep.
Yeah, that's between the buyer and their lender and their insurance. I mean, from a buyer standpoint, I'd want a more complete inspection. Then that's from the buyer, because it's an as-is contract, I assume. And so it's imperative that the buyer knows what they're getting into buying that house. So I would advise, well, you know, that's between a selling agent and their buyer, but you would say, you know, buyers can do their own inspection. Just let me know when you're done type thing. You know, disclose, but that's them. Hey, Mike, that's you. I think it's from the point when they discovered it, and then the time period starts from then, right?
Yeah. I think you don't have a defense that you forgot. Ever.
But it all depends if the buyer's coming after you. Yeah. You know, 20 years is probably a long time, but I think the statute of limitations starts when the buyer discovers there was some type of misrepresentation or failure to disclose, and some damage or some fact of the property has a material effect on the value. At that point, then the buyer has a certain amount of time to move on you as a seller.
Sure. If it was something the seller knew, and during that 5 years, nothing the buyer did, you know, exacerbated it or brought it to, like, I don't know, maybe termites, right? If you don't know. And I think your damages would probably be more limited in that situation because the buyer does have a little bit of responsibility to maintain the home after closing. But if it's something the seller knew and the buyer just didn't find out about it until 5 years after closing, they would still have some remedy.
These issues are hard for buyers to. You got to have a smoking gun. You got to prove to a judge that the seller did know and didn't disclose. You know, the seller's going to have their argument, hey, I didn't know about it. And then the buyer has to prove that the seller did know about it. It's a very hard hurdle to overcome a lot of the times.
Okay. All right. Yeah, I know. Some of these questions have already been answered, Garrett, but I'm going to ask you the question, and if we've already covered it, then you can decide. I think we have. What is the difference between flood insurance claims and homeowners insurance claims? Did we talk about?
Yeah, that is pretty simple. Everybody knows flood insurance is when water comes up, and hazard insurance is when water and other damage comes down. I think everybody understands that, correct? They're two different policies. Remember that.
Okay, that's it. And then Amy talked about the NFIP assumption, and I think some of your questions, what is assignment of insurance benefits contract? Is that the same thing?
No, well, the assignment of insurance benefits was very prevalent until January of 2023 when they terminated, or the Florida statutes prohibited them. But what assignment of insurance benefits is that, and it was utilized properly with a lot of folks, but there was some abuse. But you have a claim, you have damage, they have a claim, and a company, a contractor, whatever, come to the homeowner, and the homeowner would assign their claim rights and the benefits to that contractor, and then the contractor would make the claim, take care of all the money, take care of all the repairs, that type of thing. But in January 1 of 2023, they banned any new policies to have the assignment of benefits claim. Any policies written before that, yes, that is still active. After that, no more.
they found that many insurance companies have purposely overcharged. They're investigating that now because they were just pocketing, their investors for the people that are behind it. Now, when it comes, obviously, I know also that in Florida has the highest rate of cost of insurance in the entire nation. I did a little investigation about that. And I also know that our governor had put in place some of those legislations to alleviate the problem. Based on that, and with the new storms that were completely, obviously unexpected, have you seen improvement or worse? I know that some insurance companies were coming back into the state and giving more options and better pricing. But now after the storms, do you know where the state is regarding insurance going forward?
The answer is no, they're always tweaking it, but it always seems like the tweaks don't really bring down the premiums. I think no storm for a long time really helps probably the most. I think we're in for, going back to the answer, what is the insurance companies doing and what is the legislature doing? And the answer is I don't know what's coming out of this storm. I'm not sure if there's anything going on in the new legislative session. Do y'all know of anything? So, but they're always going to be tweaking it because it gets to politics and that type of thing.
And the cost probably will go up.
Yeah.
They tend to go up and not down. But that's being very prohibitive. I mean, especially with some flood insurance, moving the lines, it seems like when they need more money or they move the flood insurance lines out, increase the amounts, they do some other things to increase the premiums, and they don't never seem to come down either.
I haven't seen anybody not be able to get insurance recently, though. I don't know if you guys have. I think everyone's still able to obtain a policy. It's just pricey. Yeah.
He was afraid to submit. He was afraid they'd cancel his coverage.
Mhm.
We all did that.
Questions more of an insurance question. Say the person submits a claim, the insurance company pays it up, but the owner doesn't make the repairs. What if you, I had a customer where just during the last hurricane, the whole page was damaged. They submitted a claim, but the insurance company came back and said that the repair was $7,000. You contacted the contractor, they repaired it for $3,000. So the sellers basically paid for it themselves. Does that claim automatically close if they don't? Do they have to physically do something to close that claim? Or does that remain an open claim if in fact they fixed it themselves? I know that's kind of an insurance question, but is that something that they have to proactively say, close that claim now so that it doesn't show as an active or an open claim?
Are they trying to get the $3,000 reimbursed by the insurance company? I would say definitely get with the insurance company to close that out. Yes, because then it may have an impact on future trying to get a different policy, or if you're selling, that buyer may see, hey, there's an open claim, never been closed. Right. Can you withdraw that claim, I guess is an issue, is a question. I think once it's in the system, it's in the system.
Yeah, I was going to say it might depend on the insurance company as well. I self-admittedly hit a light pole right outside of my driveway, and at first we were going to run it through insurance, and then we realized it wasn't worth it. And I got notification saying if we don't hear from you within 60 days, we will automatically close your claim. But that was my specific company, so they may all have different policies on that. Calling. The question was whether we've heard that flood insurance may be required for everybody in Florida eventually. I have not heard that.
I have not heard it either, but the way they're moving those lines around, it wouldn't be surprise me if we end up doing the same thing you're talking about.
Just another way for citizens to charge more, I guess.
I did hear citizens expanding their qualifications. Yeah.
Okay, Michael. What should buyers do during hurricane season to protect themselves?
Sure, thank you.
Hmm.
First of all, I want to just say I'm sure it was the light pole's fault.
Obviously.
So buyers have really a number of things that they can do. First of all, if your buyer's buying a piece of property, get their insurance quote early, get it bound early before the storm comes so that they don't have to worry about it postponing their closing. Alternatively, if they don't want to close when a storm may be pending, maybe they don't want to do that, but it's something that they should consider and decide, am I okay with my closing being postponed? If they're, say, selling a property up north and moving down here, and they want to keep their closing date no matter what, they need to bind their insurance very early. So don't wait for the storm to be in the box. A buyer should also, these days, look into, as we've talked about, the insurance claim history on the property, the repair history on the property. See what's open, see what's out there. If it's a home that's in a flood zone, a special flood hazard area, and built below the base flood elevation, which is a determination a buyer should make during their inspection period, they need to look and see how many repairs have been done to the property in the past to see if further repairs are going to be allowed under FEMA's regulations and the FEMA 50% rule. And those are really the primary things that we're seeing these days that a buyer really needs to do to protect themselves in this new world.
Yeah.
So the question is, where do they get these records? So first place, of course, ask the seller, see what the seller is going to tell you. Secondary, check the permit records for the county or municipality that the property is located in. And third, you can use your eyes. You look around, and if the home is below the base flood elevation, there may be things that have been done to the property that might not show up in the permit. So if it's got all brand new floors and remodeled bathrooms, then they might have spent a whole bunch of money that you're not going to see a permit record for. And those are issues. The base flood elevation information, which is you can get from FEMA's website. So FEMA has a website which shows all of the flood zones. It's MSC for Map Service Center.fema.gov. And you can type in any property address and you'll see the actual flood map. The same information is also available on the property appraisers' websites and various GIS systems, but I always recommend going right to FEMA because those are the official maps. And from there, you can see if the property is in a flood zone. And if it is in a flood zone, which is A or a V designation for the zone, then you need to go and say, how high is this home built? Is it built above the minimum height that it needs to be built? That information you can get from, hopefully the seller has what's called an elevation certificate that they can give you right to begin with. If not, you can hire a surveyor, and a surveyor will obtain or figure out and certify what the elevation is and compare that to the base flood elevation for the particular zone that the home is built in. It is really critical in this day and age. Our municipalities weren't so concerned with the FEMA 50% rule just a year and a half ago, and now they're all paying attention. I'm sorry, I missed that.
Explain the 50-50 rule.
Oh, so and I'll get to that in 1 second. You were going to mention something.
Explain that the contracts aren't automatically contingent upon acceptable flood insurance. So you have to put a special.
That's right. So Garrett has a great point. There's no default contingency in the contract for flood insurance. There's a little disclosure in paragraph 10 about having 20 days to see if the home is above the base flood elevation, but there's no specific contingency. And a lot of the times you don't know in those 20 days. And there's no other specific contingency that's at all going to address that. The FEMA 50% rule is a regulation that the National Flood Insurance Program requires of participating communities. And pretty much all communities are participating. They subsidize our flood insurance. Our flood insurance would be crazy expensive if our communities didn't participate in the program. And the National Flood Insurance Program says that if your home doesn't meet the requirements, and most importantly, isn't built high enough, then you can only do repairs or maintenance or improvements to the property as long as those repairs, maintenance, and improvement don't exceed 50% of the improvement value. So I know there was a lot to that. Let's say you have a home, it's not in a flood zone, none of this matters. If you have a home that is in a flood zone, you next figure out, is this above the base flood elevation or below the base flood elevation? And that information you can get from your elevation certificate, either from the seller or from your own surveyor. If you're above the base flood elevation, none of this matters. If you're below the base flood elevation, that's where we have the issue. That's where we have the limitation where you can't spend more than 50% of what, not the whole property, but what the improvements are valued at. That is a great question. So the question was, how do you determine the value of the improvements, which is then going to implement the limit on how much you can spend. So the county in Sarasota County tells you you can take their assessed value of the improvements and multiply that by 1.2. Manatee County is awesome on their property appraiser's website. They show you the FEMA value in red. So you can go on and use that value if you want. If you don't like either of those values, you can hire your own appraiser, and your appraiser will go out and appraise the value of those improvements. And then you have to fight with whatever the municipality is to say, here's what the improvements are valued at.
One quick note about permits and permit searches. Both Manatee County and Sarasota switched over to different platforms over the past couple of years. So sometimes it's a little tricky to find all of the permits. One easy thing you can do is just submit a public records request and ask for all permits on a particular property. And so if they have record of them, they'll just send you an email, a nice little bundle package with all the permits for a property. It's a public records request. So Sarasota County has a link on their, if you just Google Manatee County public records request or Sarasota County public records request, it'll take you right to the link and you could just do it all online.
I don't know Manatee County's offhand. Sarasota County is just public records at sc.gov, and you send them an email, they get back to you in an hour or two, and it's really great.
So yes and no. So like I think it's Manatee County, anything older than 2018, they just give you these Excel spreadsheets that are really hard to read and figure out what the permit was for. So if you ask for all the records, they're going to send you the actual permit records as opposed to just a line item on a spreadsheet. Yeah, they'll give you everything. At Sarasota County, I find a little easier to find permits than Manatee County, but I've just gotten in the habit, if I think something's missing or I think something looks off, I just do the public records request. 2018, I'm not sure about Sarasota County. Maybe 2008 or even further back. Yeah, they get, and the way you search, yeah, the way you search like parcel ID or address or whatnot, it just gets a little hairy and they're all different. So that's why instead of remembering the best way to search on each county, I just submit the records request.
Yeah, the associations have to maintain insurance. It's actually a requirement that they made insurance. Yeah, liability and the hazard and flood, if they're within the flood zones.
So I'm thinking, when you're talking about excluding public records, I think it would be ideal that immediately with all properties, just make that request for all public records, and so buyers are, waiting to have a couple of reviews.
Well, we do as part of our searching. It's not only do we search public records for judgments and that type of thing, buyer, seller, property, but we do get a municipal lien search. That municipal lien search incorporates a permit search, any liens from a municipality or county, and whatever past due taxes or assessments. So it is part of the municipal of what we look at in the municipal lien search. Yeah.
It shows expired and closed permits as well. Yeah. You probably don't see it a lot of times because when you get a lien search, you're looking for open. So if there are no open permits, sometimes you just move along, right? But it should be in there, should be a list of all the permits. Yeah, the only thing I will tell you is sometimes when there is a long closing date, we might wait to order the lien search because they do charge for updates in certain counties. So if you want it done right away for whatever reason, just tell your closing agent, please order the lien search right away. It's also a hard cost. So if the contract cancels, the buyer would be responsible to pay it.
Well, it's public information. So you're going to get it on behalf of your client, give it to your client, and that's it.
But if they didn't know about something, you're now giving them knowledge. So not necessarily sure there's anything in there that would, harm them, but you are providing them with knowledge of all the permits.
Just something we could talk about, get insurance, does it get stolen, especially if you don't buy, well, if you're living on the property or selling it. Is that something you're seeing a lot around here?
The answer is we see it. Both in fraudulent sales where they impersonate a seller, and it's usually the things we look for are out of state, vacant land, sellers never appeared anywhere, that type of thing. It's hard to get a hold of. We also see a lot of fraud on trying to intercept money. That is, they're getting better. Both of them, all of them, they're getting better and better with AI. They're going to get better and better. So you have to be very, very diligent. But there is that thing on the counties that you can put your name on a list and they let you know if anything's being recorded, because the faster you discover it, the faster and more success you can have to battle it. Yeah. Yeah. Yes, the counties have a sign up, an area you sign up, and they will notify you of changes to your title. And to be diligent, and I'm guilty of not doing it, but check the public record. Manatee County, Sarasota County Clerk of Court, everything gets recorded, is in there. Anybody can look at it. It takes 3 seconds to pull it up. Put your name in there or whatever name you want, and you can see if any changes have been made recently, because that is a permanent record, can never be manipulated. I should say never, should be never be loaded.
I have that insurance with home title lock because I had a friend that it happened to, and I've had every other kind of insurance. I mean, fraud you can believe in my life. So I have it. It's like $200 a year, but it's worth it for me. But anyway, Okay.
As an aside, another great use of that system, and it's a little off topic, is these days with our exclusive buyer agreements,
Yeah.
your buyer owes you a commission if they buy a piece of property. You might want to set up an alert for your buyer in case they're exclusive to you and you otherwise would have no idea that they're going to buy a home. So it would be great to get alerted that your buyer who you had an exclusive relationship with spent 10 months showing homes, all of a sudden bought a home and you had no idea because they stopped calling you the last month, and set up an alert under their name to see if a deed gets recorded in their name.
Okay. Amy, property tax ramifications after hurricanes and storms.
Sure. So this topic is, for some reason, has become near and dear to my heart because I feel like a lot of people don't take advantage of this. One thing I will say is the deadline for property tax refunds for 2024 has now passed. So that deadline was March the 1st. So if a home is uninhabitable for 30 days or more, the owner does have the ability to apply for a property tax refund for the portion of the year in which the home was uninhabitable. That has passed, so we won't really get into that too much. But now we are in the point of homes being reassessed on January 1st. There should be a lot of homes reassessed on January 1st for a lower value than 2024. I don't know about you, but the property appraiser is not always my friend when it comes to property valuations. They are not going to voluntarily say, oh, I think your home was damaged, so I guess I'll, take off $200,000 from its value. Both Manatee County and Sarasota County have an online link to allow you to report damage after the storms. By reporting the damage, it provides the property appraiser kind of a push to go out and look at that property as of January 1st to see if the property is still damaged and still uninhabitable. If it's uninhabitable, there is a chance that the property value will be assessed only at land value. And obviously, if it's damaged, the property should be assessed at a lower value. So I think that is going to come into play for owners and for realtors in a couple of different ways. So number one, prorations. Prorations are going to get a little funky on some of these homes that were badly damaged because throughout this year, up until, let's say, August, we're all going to be looking at 2024 values. Home values are assessed on January 1st of each year. So the value that I'm looking at a closing right now is going to be January 1st. It's going to be pre-storm values. So that number for 2025 could drop dramatically. And so my prorations are going to be very skewed. Most closing agents, as part of their closing agreement, have language that says that both parties, and this is in the contract too, that if the taxes are vastly different, both parties are going to agree to settle up, right? If one side owes the other side, they're going to pay it. So I think everyone just needs to keep that in the back of their mind and to advise both their buyers and sellers that property values for 2025 could get a little strange, and prorations may need to be adjusted once these bills come out. The question is whether the property appraiser cares that a property is not selling. And the answer is probably not. Every year, if those who don't know, you get what's called a trim notice in the mail around August. Maybe strategically, I don't know, but you only get a very small window to challenge the property appraiser's valuation of your home. It's 20 days, and that 20 days doesn't take into account our snail mail that we have. So by the time the homeowner gets the document, they're probably looking at less than 2 weeks to actually challenge the valuation. I think this year it's going to be very important for everybody to look out for those to see how they're, obviously if you didn't have damage, it's not going to be a big deal. But if you had a lot of damage to your home and it was damaged on January 1st, pay close attention to your trim notice and see if you believe that it would be worth it to challenge the assessment. To challenge the assessment within that 20-day window is very easy. It takes about 5 minutes to fill out that initial application, and it's only $15. So my advice would be fill it out. If in doubt, fill it out. You can always withdraw it. You can always change your mind. If you don't have an appraisal at the time, that's fine. You're going to have a couple months after that to actually get prepared for hearing. So if you have any doubt that your assessment is correct because of storm damage or for any other reason, go ahead and file a challenge, secure your spot to challenge, and then over the next couple of months, you can get your appraisals done and you can figure out if you actually have grounds to challenge their valuations. I don't think they look at that. They do their own
They
appraisal.
don't talk. No, the appraisal is a private document between the lender and the buyer and the appraiser. Yeah, they're statutorily, they're required to make their own market value determination.
They can maintain their homestead exemption for a period of up to 5 years, as long as they have the intent to rebuild. That was changed recently from 3 years to 5 years. But as long as they have the intent, then they cannot try and get a homestead anywhere else. They cannot port their exemption for 2 years onto another property. They have to keep it on the same property, and they have to give the property appraiser notice that they are intending to rebuild.
That also goes back to what Amy was saying about get with the property appraiser and bring those property taxes down while that property is vacant land.
Oh yeah, and they will. But there is some guidelines that they have to follow when rebuilding. So if you have a client who, let's say, lived in a siesta key property for 40 years, so their tax value was very, very low, and now their house is leveled and they are rebuilding. If they utilize the same square footage, or I think it's up to 110% of the original square footage, the property appraiser is limited on how they reassess that property. They have to reassess it back to the original improvement value before it was leveled. Now, they're going to try and get around that if they can. Obviously, that's their business, is to make money. So if they can find a loophole to say, okay, it's 111% of the original square footage, or you added on a whole new barn, that's a new improvement. That's not a rebuilt improvement. They will give a new valuation to that new improvement, but they are constrained to use that pre-damage value if the rebuild complies with the statute. And like I said, I think it's 110% of the original square footage.
These questions are running off. Wait a minute. Garret, do you have something else you want to talk about regarding hurricanes?
Related to a lot of what we're talking about, and I think all three of us can jump in on this one, is how can how can you protect a seller, and how can you protect a buyer if there's pre-storm, post-storm damage? One thing I'll do a buyer, and the fact that if you are buying a piece of property that is damaged and that they're moving forward with it, remember I think we touched on it earlier, the as-is contract doesn't, is just that. The seller is not obligated to fix anything. So to protect a buyer, make sure you do an addendum to the contract to reflect what items are being corrected, who's to correct it, by when. Seller has at seller's cost prior to closing with licensed personnel shall complete the following repairs prior to closing. Then it makes it part of the contract, and if seller does not make those repairs, then the buyer can either, the seller just can't back out. The buyer would have rights, either specific performance or terminate, get their money back. Do you want to address protections for the seller?
I was going to say for buyer and seller, I'm really big on pictures. Take a lot of pictures. Take pictures when you're walkthrough. Take pictures at inspections. Don't just rely on the inspectors and pictures. People have very differing opinions on what things look like 30 days prior. So the more pictures you can take, videos you can take showing the property's condition, the better. And again, that's on both sides.
I made a list, and it's just a laundry list that you can pull up online, but it's, always review your insurance policies. Don't sign anything when people just show up at the door and say, hey, I want to do this. You make sure we examine that person, make sure that they're either licensed to contract, the insurable. Pictures. Make emergency repairs. If it is a big hole in the roof, you can make emergency repairs. That is reimbursable by the insurance company. Make inventory of all the personal property, both before and after. It's always good to just, when the storm's coming, go back around with a video camera and just take video of everything inside. It shows not only the condition, but it also relates to personal property that may be damaged. And then that's about it. I'm sure there's a whole bunch more, but there's a lot of things we can do to protect ourselves when the storm does come. These things are usually on the back of one's mind. You're usually putting the sandbags up, the hurricane stuff on, but make sure all your insurance and all your papers are secure, that type of thing.
I don't know. I would assume, FEMA has every rule and regulation you can imagine. So I would think they would have requirements on those types of items. If there's any water damage, they probably require X amount to be, carved off. But I just don't know if private homeowners insurance companies have those same rules. I also don't know how drywall really works. So I don't know if you have to buy pieces of a certain size and whatnot. Oh, there you go.
This base is wet, try to cut it to give a buffer, so that you can place the drywall easy. So it's either 2-4 or 2-2, so that you're not having to subdivide the drywall even further and adding more cost. So that's basically why there's a rule of thumb with these.
That's the dimensions of drywall. That makes sense. I think this is a great question for our mitigator. The question was, if there's electric plug and the water is near that, do you have to replace the electrical, either lines or plug?
Pocket salt water, that you kind of hold out a lot of problems. I'm actually bracing myself for a fire job. You'll have a good, you're kind of hot. That same thing to start catching fire. A lot of people have had deep salt water in the home. Magically, their appliances are working, but some point, really be a problem.
What about freshwater? What about freshwater river, like very heavy?
Salt water is much better. That's why I love it. Electric cars have to fire and that sort of thing. So, and insurance will generally pay to have your car. That's the fact. Just be careful.
Thank you.
But off of that, supply line for these old CSPE homes, for example, they're all underground copper coming up. And if you already have the drywall out, if you have a client buying one of these properties to remodel, rerun all the time. Because it's all gonna have probably with different.
So go to PVC. Are they using now? Right, okay. Don't listen to me.
Hey, Garrett, I think he means, replumb the house, but like up through the attic, right? Don't try to
Yeah.
put it under the ground again. Yeah, it's really bad. Oh, I've seen some horrible things, yeah.
So there is the question is whether or not a buyer's new insurance company can check the claims history based upon another insurance company's claims. And the insurance companies share information, but it is not very clear. It is not anything that we as consumers have any knowledge of. My understanding is there is essentially a secondary, almost credit system where they keep track of claims. But we don't have access to that information. They don't have to share that information to us, with us. And the insurance company may or may not have it. So you really can't rely upon it. They may have it, they may not. They definitely don't have to share it with you, even if they do have it. It's really kind of a gray area. You are, if there was damage, hopefully the inspector is finding the damage which would have necessitated the claim. And so if you see something that's been obviously repaired, that should raise your question, how was this paid for? And you might want to ask the seller to give you the receipts for how that item was paid for. If they claimed insurance for that, you can, certainly ask. Yes. Or so the question is there restrictions on selling a damaged home?
A mold.
And legally, no. Anybody can sell anything to anybody, provided they own it, and you can have a legal effective transfer of the property. there's always concerns that come with it. If the property is going to continue to exist in its dilapidated or damaged state, it could be subject to code enforcement violations, which your buyer might have to deal with. The seller may have code enforcement violations, which would hopefully appear in the public records if they've gotten to that point. But to answer your question, legally, there's nothing that would prevent that property from being sold and effective transfer of title to take place.
One other avenue that you want to not forget about are neighbors. So, these neighborhoods, it's not like one property flooded, they all did. So if you have a seller saying, oh, my property was fine, walk around and ask some people. They'll tell you. People love to rat on their neighbors.
Get a mold inspection. Get a mold inspection. Have the buyer get a mold inspection.
Yep, they love it.
It's not a law, but.
Talking about what our governor said about reducing or eliminating? No, that was just a statement made, and as far as I know, no action has been taken at the Florida level.
Thing about counties or cities issuing permits to deny, fix-up permits to a new buyer. As long as it's nothing to do with the 50% rule, but just because it might be, a grandfathered in property. So something that duplex from 42, that now is no longer needs rebuilding to a duplex. Is that a consideration that buyer as well?
Yeah, so the question is, if there's a property that has possibly a grandfathered use like a duplex, but the current code doesn't allow for it to be a duplex, are there restrictions in repair and rebuilding? And the answer is yes. There are in the municipal code, there are certain guidelines for non-conforming uses and structures. Some counties and cities are a little more lenient than others. I think Longboat Key doesn't really care much, but city of Sarasota cares about everything. And I don't quote me, but I think that if a non-conforming structure is damaged and it's more than 75%, then you cannot rebuild the same structure. You have to now have a conforming structure. One thing with uses to keep in mind is that if a non-conforming use is abandoned for more than a certain amount of time, it's waived, it's given up. So I think a lot of people are in the boat of being around the 6-month mark now. And so they need to, call the county and see what they need to do to maintain their use that's no longer conforming.
Each state municipality can be different. Don't know. I don't know the Anna Maria code that detailed.
Usually there is some type of carve out for casualty damage, and you can build back in the same spot. You just can't expand your nonconformity. But a total destruction, they may have to rebuild within the new setback codes. But again, it just depends on the city or county.
Sure. So the question is, if a seller makes a claim for replacing their roof, but pockets the money and doesn't replace the roof, what are the consequences? And there's nothing legally that would prevent the seller from being able to convey the property, but the buyer may have difficulty getting insurance for that property, which if they can't get insurance, they also would not be able to get a mortgage. And it severely limits the ability to market that property or the desirability of that property for any particular buyer. So legally, they could still sell it, but practically, it's got a lot of problems. And the seller better disclose it. Disclose, disclose, disclose.
Other than disclosing, I think kind of a theme here is building in longer inspection periods, especially on homes that are on the keys, because there are a lot of things to consider. There's a lot of research you want to do. Even, even these investors who are saying, I don't care, if the property is trashed, and you still have some due diligence to do. So try and build in inspection periods as long as you can.
Along with that, I'm very hesitant when I do a contract to put 0 inspection days. A buyer seller come to me, I know this guy, this seller, I'm not gonna worry about inspections. I pretty much always force them to put an inspection period, albeit 5 days or some days in there, some reasonable time frame, because that protects the seller as well as the buyer. The buyer may say, after they get the contract, I think I do want to look at this, that, and the other. Gives them that little period of time. Plus, the seller is giving them an inspection period. If it does go to court, the seller's not looking like the bad person of not giving the buyer an inspection period. So I think I always require some type of inspection period.
Garret, I have a quick question, something that just is happening to me now, but it's a condo on Longboat Key on the beach, and the listing agent asked me not to use the as-is contract, but to use the regular contract, but to put 0% in the inspection limits, in the repair limits, and there's no due diligence period at all, doesn't want any, so I'm not going to do it that way, but.
No, I agree with that. They're trying to put the regular contract into an as-is, and it just doesn't do it, because there's still requirements and that type of thing.
Okay.
There's all kinds of steps you have to go through in the normal contract. With the as-is, you don't. And if you don't go through the steps, then they could be waiving rights.
Yeah, okay, thank you. How many minutes are we done? Yeah, we're done. I guess it's 3 o'clock, but I guess they'll be here for a little bit. If you have any questions. Thank you. Can I get a couple of your cards?